May it please the court, my name is Elmer Tukan, advocate for the second applicant.
Thank you.
My lord, the state is still constituted as before.
Thank you. This is my judgment on the bail applications filed by the accused persons. This judgment deals with, just before I proceed, this judgment is available. It can be accessed as long as it has been issued by the registrar. Once I hand it down, I will send it to the registrar for the necessary stamping. So I expect it to be available tomorrow. This judgment deals with separate applications for bail pending trial filed by the applicants in terms of Section 117A of the Criminal Procedure and Evidence Act, Chapter 907, as read with Rule 90, Sub-Rule 4 of the High Court Rules, 2021. I heard the applications at the same sitting with the agreement of the parties because they are substantially similar. The background to the applications is the same and was summarized by the applicants in almost in identical bail statements, except of course the peculiar personal circumstances of the applicants. The background to these applications is as follows. The first applicant is Moses Mpofu, Zimbabwe national, age 49 years. He resides at 5 Cambridge Drive, Greendale. He is a businessman. The second applicant is Mike Chimombe, a Zimbabwe national who resides at 541 Helensville Township, Borodale, Harare. He is a farmer and businessman. The background to this application is not subject of any dispute, real dispute. The applicants are on trial before me and 2 assessors after pleading not guilty to a charge of fraud. The trial is set to continue on the 10th of February 2024. The charge emanates from the alleged use by Black Duck Livestock and Poultry Private Limited, a year and after Black Duck, of falsified documents as supporting documents in a bid to secure a tender to supply 500,000 goats to the Minister of Agriculture. The allegedly falsified documents allegedly submitted with the bid for the purposes of meeting the requirements of the tender were a Zimbabwe Revenue Authority tax clearance certificate and a National Social Security Authority compliance certificate, both in the name of Black Duck Livestock and Poultry Private Limited. The state alleged that the applicants connived to and did submit falsified documents, well knowing that Black Duck Livestock Poultry Private Limited was not registered in terms of the laws of Zimbabwe. By making such misrepresentation, the state continues, the applicants allegedly intended to and did give the false impression that Black Duck was a registered company and juristic person and that its bid met the tender requirements. The state is alleged to have acted on the misrepresentation, thereby dealing with a non-existent entity, in brackets, and treating Black Duck's bid as valid, culminating in the acceptance of the bid, which was invalid, and the subsequent award of the tender to Black Duck and prejudice to the state. In its summary, the state listed witnesses who it says will testify that they interacted with the applicants during the processes and that culminated in the state awarding the tender to Black Duck Livestock Poultry Private Limited, which the state alleges was falsely characterized as a registered company. The state also listed witnesses who will say that the applicants falsely gave out and pretended that Black Duck Private Limited, or the aforementioned company, had performed its terms in terms of the contract and that the payment was due to the company, intending the state to act on such misrepresentation. The state has also lined up witnesses who are expected to testify that indeed the state disbursed 7,712,197 United States dollars, which are public funds, which were public funds. and to the loss and prejudice of the state. The applicants were denied bail when they appeared before a magistrate on the charge of fraud following their arrest in June 2024. The magistrate decision denying the applicant's bail was handed down on the 16th of July 2024. The applicants appealed against the refusal of bail on the 30th of July 2024. I'm just reading the background given to me in their statements, which I said is not contested. The appeal was set down for hearing on the 6th of August 2024, but could not be heard on that date because the record of appeal containing proceedings before the magistrate was incomplete. The hearing was postponed to the 8th of August 2024 to allow the applicant's counsel to attend to the record and for the state to file a response. The issues were quickly attended to, and the appeal, whereupon the appeal was opposed by the state, both on a point of law and on the merits. On the point of law, the state placed it on record that the applicants had been served with indictment papers on the 7th of August 2024 to be tried on the fraud charge on the 1st of October 2024 in the High Court. The registrar had been notified of the development. The state submitted that the legal implications of the indictment were such that it was no longer necessary for the appeal to be heard on the merits because the outcome, even assuming it was going to be in favor of the applicants, was not going to affect the detention of the applicants in terms of the who were being held in terms of a warrant issued by a magistrate for their detention until they appeared before the trial court on the 1st of October 2024 from detention. The issuance of the warrant and detention of the applicants until they appeared before the trial court was mandatory in terms of Section 66, subsection 2 of the Criminal Procedure and Evidence Act. It was, according to the state, it was therefore pointless to determine the appeal on the merits. The objection was upheld by the judge who dismissed the appeal. The applicants accepted that decision. Following the dismissal of their appeal, the applicants filed a bail application pending trial on the 22nd of August 2024 under case number HACC 148 of 24. Once again, the state objected to the hearing of the bail application by a judge before the trial court had become constituted and the trial judge had been identified and had become properly seized with the matter. The objection was upheld and the bail application was removed from the roll on the 11th of September 2024. The applicants accepted that outcome. I have before me other documents which are the notice of indictment, the charge, the summary of the state case, the summary of the anticipated testimony of the witnesses, the record of the bail proceedings before the magistrate in June and July 2024. That record of the bail proceedings reveals the evidence that was led, the respective submissions by the applicants and the state, and the decision by the magistrate. The documents were placed before me by the applicants as annexures to their bail statements. The applicants have given their defense to the judge. The applicants, in this application, the first applicant dwelled at length on his defense in his bail statement. The second applicant did not burden me with a detailed exposition of his defense. I think that was informed by the realization that at this stage, the judge is concerned more with the gravity of the crime charged and the strength of the state case. The applicants benefit from the presumption of innocence. The applicants are only required to place facts required in terms of Section 117A of the Criminal Procedure and Evidence Act and Rule 90 of the High Court Rules. And in the case of further application, the applicants are required to place new facts on which the further application is based, as contemplated in Section 116, Paragraph 6, Subparagraph 2, Roman numerals 2 of the Criminal Procedure and Evidence Act. As part of their defense, the applicants applied to the judge for referral of 17 constitutional issues issues for determination by the Constitutional Court. The application was argued over a period of 3 months, which constituted the entire third term of the High Court in 2024. This was unusually long and regrettable. The state had expected the trial on the merits to conclude within a week in terms of the state papers. The applicants are, however, entitled to exhaust all local remedies in defending themselves. So the fact that the constitutional matters took 3 months cannot be held against them. Suffice it to say that the request for referral was refused when I held that the request was frivolous and vexatious. The applications before me were made 2 weeks into the third term vacation, following the adjournment of the trial. The bail statement by the first applicant is laborious, argumentative, and clearly does not comply with the mandatory template of bail statements as set out in Rule 90 of the High Court Rules. The template is in the form of a questionnaire meant to solicit basic information from an applicant about who he is, the details of the state allegation against him, perhaps his attitude, the relief sought, and in the case of an application made in the High Court where the bail was refused by a magistrate before, and the reasons therefore. The bail statement is therefore expected to be simple, unemotional. In other words, it has to be a simple, unemotional presentation of facts to assist the judge in considering their entitlement bail in terms of Section 117 of the CPND Act. Mr. Maduku got it right. There's no place in the template for lengthy narrations or case law or arguments. He just presented the facts in answer to Rule 90 of the High Court Rules. I urge lawyers to emulate that. The application must also provide all the information required in terms of Section 117A of the CPND Act. Now, if one adheres to the practical guidelines set out, which guide judges and magistrates in considering bail, it becomes clear that a bail matter is essentially a factual inquiry, most of it. The law is already set out in the statute. The judge is instructed to grant bail except where the judge finds compelling reasons to deny bail. The judge is given very practical guidance on the factors to consider. Argument may then be presented at the hearing, although one may want to place authorities before the court beforehand, but that does not have to form part of the bail statement. The court also receives guidance in dealing with bail applications pending appeal from Section 116 of the CPND Act as to who bears the honors and who bears the burden, depending on the offense charged and depending on the circumstances prevailing. My understanding is that honors denotes the duty on the applicants in terms of what they must do in order to succeed. Depending on the case, in this particular case, the applicants would discharge the onus on them by simply providing the information that is requested in Rule 90 and 117A of the CPND Act. Well, and any further information which is stated in Rule 90, which may be in favorable or favor the granting of bail. In the case of further application, the accused, the applicant, is the honors to place facts before the court. as contemplated in section 116, subparagraph C, let me take that again. Section 16, paragraph C, subparagraph 2, Roman numerals of the CP&E Act. Burden is described as the burden to adduce evidence from which a juristic effect may be inferred. This may shift from time to time in a trial or in an inquiry. See South African, there is case of South Cape Corporation Private Limited versus Engineering Management Private Limited, 1977, Volume 1, South Africa Law Reports, which begins at 534, but this is discussed at page 548. The onus or burden, whatever the case may be, is discharged by placing facts before the court. It therefore becomes clear that facts are very important in a bail application. They are critical. It is not really necessary to quote the Constitution. A bail application is not a constitutional matter. A bail application is not made in terms of the Constitution. It does not involve the interpretation of the Constitution. So as much as possible, the Constitution must be avoided. Because what the Constitution says is repeated in section 117 of the Criminal Procedure and Evidence Act. A bail application is based on and considered on the basis of what the CP&E Act says and rule the High Court rules, which give application to the right, to bail, loosely stated. In other words, the CP&E Act operationalizes the right in section 50, subsection 6. The right then is operationalized in detail following the extensive amendments to the bail law in the Criminal Procedure and Evidence Act in section 115, section 116, section 117, section 117A, and other relevant. It appears to me that the legislature took a deliberate decision to collect, consolidate, and adopt and modify the common law on bail for ease access and ease application, because bail matters are very important and strategic in nature. They are important because they concern a right which is protected by the Constitution. The right in section 50, subsection 6 is sacrosanct. They are also strategic in that society expects the law to protect it. Society expects people who are reasonably suspected of committing crime to be dealt with in accordance with the law. So the release of an accused person on bail should not prejudice justice and the rule of law. Those are the competing interests in a bail matter. I will not go through the lengthy exposition of the first applicant's defense, but I note that in essence, the first applicant was simply saying, while admitting that he is a director of the company which benefited from the impugned transaction, he denied personal involvement in the tender processes. He denied making alleged misrepresentation. He denied benefiting personally from the impugned transaction. He averts that in any event, the dispute giving rise to the charge for which he is being tried involve a company for which he just happens to be the director, and the state and the state on the other side. It is a contractual dispute with no criminal connotations or consequences. The second applicant denies personal involvement in the tender processes and says his presence at some instances was innocent. Both put the state to the proof of his allegations. The first applicant cited a lot of authorities. I've already criticized this approach. An applicant can cite authorities in preparation for argument and can place them before the court beforehand, but clearly, in terms of Rule 90, they don't need to form part of the bail statement. The first applicant also submitted that the Constitution guarantees the applicant's right as an accused person, detained and suspected of having committed crime, to be released unconditionally on appropriate conditions pending trial, unless there are compelling reasons justifying continued detention. The first applicant also submitted that it was submitted on behalf of the first applicant as well that the right spoken of in section 50, subsection 6, is concomitant with the right to liberty, which must not be interfered with unless there are compelling reasons justifying detention pending trial. He cited the cases that will appear in the judgment, Mutsaka, BT, Mpofu. It was submitted on his behalf that the judge should waive a possible lien in favor of the liberty of the accused if this would not prejudice the interests of justice. He moved me to balance the interests of the administration of justice against the constitutional right of the accused persons or the applicants to liberty, and submitted that the right to liberty becomes more important in light of the presumption of innocence. Every person is presumed innocent until proven guilty. Section 117 of the criminal procedure provides for the general entitlement to bail unless the interests of justice dictate otherwise. The presumption at law is that the applicants are innocent until proven guilty. Obviously, these submissions also apply to the second applicant because he associated himself with submissions made. I just wish to observe that the submissions are correct. The legal expositions are correct. But as I said, all these principles find application in section 117. One does not have to regurgitate that because they are given expression in section 117 of the criminal proceeding. But anyway, an applicant is not precluded from saying what is favorable to him. But I would suggest that, mindful of that, what should be of importance to a practitioner is then, providing the facts, because the law already says, section 1 already says, an accused person shall be released unless there are compelling circumstances, rather compelling reasons. The second applicant then submitted further, the first rather, submitted further that the state case against the applicants in the indictment papers was very weak and doomed to collapse. The state had failed to advance any compelling reasons. And that the state had not used any evidence to prove the existence of compelling reasons after the completion of the investigations to justify their continued application. I can see that the first applicant there was making a distinction between the application that was made before the magistrate and the application that was being made now. But I don't know why they insisted that it's not a further application. The applicants urged me, both applicants urged me to treat their applications as initial applications. I thought initial was the best word. So many words were touted: fresh application, initial, first application. I just thought initial maybe it reflects that there's nothing before it. The earlier application before the magistrate had become had been rendered irrelevant and inconsequential by the indictment of the applicants for trial in the High Court and their detention in terms of a warrant. The earlier application before the magistrate and evidence led thereat had to be erased from memory. The justice was not expected to pay attention to the bail application before the magistrate, the outcome, the record of the bail proceedings which they had submitted, which the applicants themselves had submitted with this application. They submitted that the state was required to call investigating officers from ZAC or any other witnesses, despite that the witnesses were called during the bail application in the magistrate court. They submitted that the applications were initial applications and not further applications in terms of as contemplated in section 116, paragraph C, subparagraph 2 of the CP&D Act. The applicants, Mr. Judicial submitted that this cannot possibly be an application based on changed circumstances as alleged by the state, because the High Court cannot be reduced to the level of the magistrate. I must deal with that straight away. Our judiciary is one. When a matter is dealt with by a court within the hierarchy of the judiciary, which is competent jurisdiction, then and solved, then the issue of hierarchy does not arise. It only arises if that decision is to be challenged. But a decision made by a magistrate and a decision made by a judge is simply as binding on the parties as, I'm simply trying to say that a decision made by a magistrate is just as binding on the parties as a decision made by the High Court or as the higher courts. So the distinction by Mr. Jetero, I was unpersuaded. In response to the state allegation that the applicants failed to disclose pending matters in their bail statements, they said that the applicants said they had been candid with the court. Such disclosure had been made in previous matters, which are HH 3459 of 24 and HH 409 of 24. And in the application for referral, which I've already alluded to. So, there was disclosure. They argued that in any event, nothing turned on the requirement for disclosure because pending matters were irrelevant to the bail applications before me. As I've already said, the second applicant largely associated himself with the submissions made by Mr. Jetero. And which also include that the applicants were willing to stand trial and that their conduct before and during arrest was indicative of the fact that they would not abscond. They became aware of the allegations which were widely publicized before the arrest. They contacted Zach from China indicating their willingness to attend at the commission. They did that as soon as they were back in the country. Initially they were excused, but later they were invited to go back to the commission and they duly complied. Whereupon they were then arrested and taken to court. They cited the case of S versus Mambo, where an accused who had been aware of the charge for some time and had not absconded after traveling to South Africa and back and then surrendered himself to the police was granted bail on appeal. They submitted that although the applicants were being tried for a serious crime, that factor alone was not sufficient ground to deny them bail, because their defense was plausible. They cited the case of S versus Makamba. The applicants further submitted that they had no intention to interfere with evidence. The state had not shown that they had at some point interfered with evidence. The fear of interference was just speculation and bold assertions by the state. They cited the case of S versus Hasi. The state had completed their investigations. They submitted that there was no risk of the applicants, that the applicants would commit similar offenses if released on bail because they had no previous convictions. They cited HE versus Piri, and that the applicants had no intention to disturb public order. The applicants were simply dealing with the findings of the magistrate. In response, the state resisted the suggestion that the earlier application before the magistrate had become irrelevant. The state submitted that the matters before me were further applications as contemplated in section 116, paragraph C, subparagraph 2 Roman numerals of the CP&D Act. In other words, they were supposed to be named, the state said these applications were supposed to be named applications based on changed circumstances. And failure to give the applications that name was fatal, and that they were supposed to be struck off. According to the states, in any event, nothing had changed with respect to the finding by the magistrate that there were compelling reasons to deny the applicants bail. The state listed the compelling reasons found by the magistrate. They are the likelihood that the applicants would interfere with evidence investigations and state witnesses. That the applicants would abscond. This was based on the fact that the court found that the applicant's residence remained disputed. The first applicant's residence remained disputed regard being held to the issue of an uncompleted building, and that the title deeds by the second applicant were just a piece of paper which had not been verified, and that the second applicant had given a false address where a certain white man, one Mr. Brown, was staying, and that there was a manhunt for the accused persons when they failed to appear at SAC, and that Mr. Mugia, who appeared for the second applicant, told Zach during the manhunt that the applicants had become hostile and could not be brought. The third compelling reason listed by the state as having been found by the magistrate was that the admission to bail would undermine public order, and that there was likely to be a public outcry, and that there was likelihood of undermining peace, security, and order, and that their admission to bail would jeopardize the proper administration of justice, including the bail system. The state argued that these compelling reasons remained extant and relevant because they triggered the automatic effects of Section 66, subsection 2 of the criminal. Sorry, let me read that again. The state submitted that the findings of by the magistrate remained extant and relevant. It submitted that the consequence that they triggered the automatic effects of Section 66, subsection 2 of the Criminal Procedure and Evidence Act, Chapter 907, in terms of which a warrant for further detention was issued by the magistrate who indicted them, and the accused persons were detained until they appeared before the trial court on the 1st of October 2024. The state submitted that Section 169 of the Criminal Procedure and Evidence Act, which says that bail is terminated when the accused pleads to trial, did not apply to the applicants because they were never granted bail. The provision was of significance only to accused persons who were granted bail before being indicted, who are permitted to apply for the reinstatement of the bail in terms of that provision. The state submitted that the trial having commenced and adjourned, the applicable law was set out in Section 167(1) of the CP&D Act, which provides that when a trial is postponed and adjourned, the court may direct that the accused persons be detained until liberated in accordance with the law, or release them on bail, or extend the bail which has already been released, which has already been granted, or may extend the recognizance. The state submitted that the record of bail proceedings in the before the magistrate was already before me, and that it was in fact contemplated in Section 117A, subsection 7 of the CPA Act, that that record ought to be before the judge who tries the matter. Of course, subtracting what needs to be left out in terms of the statute. That records contain, the state submitted that the record contains all the evidence that was accused at the bail hearing and the court's finding on the compelling reasons. There was therefore no need to lead evidence afresh. There was therefore no point in disregarding what is already before the court in terms of its finding regarding compelling reasons. So those were the state submissions, which I continue to read. The state submitted that the applications before me were further applications and could only succeed if they were based on new facts. There was no sound legal basis to treat them as initial applications where evidence should be laid all over again. The state submitted that the evidence of the investigating officer and other necessary witnesses was already before the court, and there was no need to adduce such evidence afresh. All the state was required to do was to rebut the existence of changed circumstances, one, or where such circumstances, changed circumstances do in fact, rather, where circumstances have in fact changed, to prove that the compelling reasons still exist despite the change in circumstances. The state submitted that the present application ought to have been made in terms of section 117 as read with section 116, paragraph C, subparagraph 2 of the CPND Act. They cited many cases: Mwamuka, Barros, Rans, Kastamba, and Shopper, and Chukumba. Oh, the citations are in the judgment. The state submitted that the applicants have already shown their unwillingness to let the trial proceed. The state submitted that the applicants put up a brave show of resistance at the commencement of their trial. The state was referring to the refusal by the applicants to plead, to have their defenses read out, and the initial resistance to being tried by assessors above 70 years of age. The state submitted that such resistance is not consistent with the expectation that the applicants would assert their right to a trial within a reasonable time in terms of section 69 of the Constitution. The state submitted that this trial would have been completed in the third term of the High Court, in the third High Court term in 2024, but the matter had not made any meaningful progress. The state therefore urged me to to hold that against the applicants. As I've already said, the third term was full of activity. The matter was being tried. The accused persons, who are the applicants now, were exercising their rights to remedies available to them. I therefore refuse to hold anything, at least with regards that, against them. The state submitted that the failure by the applicants to disclose that they were facing other charges for which they had been denied betrayed a sinister motive. He admitted that the applicants realized that disclosing the pending cases would influence the judge to find that there was a greater incentive to abscond. Indeed, section 117A, subsection 5 of the CPND Act required the applicants to make that disclosure. But as I've already said, they said they made it. I accept that I, being the trial judge, was aware of that disclosure which was made during the application for referral. So I will not hold the non-disclosure against them or as an indication of a sinister motive. But I will take into account that fact. It is a relevant fact. The state submitted that the applicants have not highlighted the changed circumstances from the time they were denied bail up to now. If anything, the situation has since worsened from the time that they were denied bail by the magistrate. So the state submitted. The state submitted that the assertion by the first applicant that the state case was hopeless, if bona fide, ought to have translated into a demand for the finalization of the case. The state was convinced and persuaded me to find that the applicants are stalling their trial on the merits. And to bolster their argument, the state submitted that the first applicant had used the words, "if we are going to trial at all," in his bail statement, which the state says is a slip indicating that he did not want to be tried or that the trial will not proceed. The state also submitted that the second applicant in paragraph 28(5) of his bail statement stated that the trial may not be completed in the near future given the constitutional litigation that is taking place. indicating that he does not contemplate a speedy conclusion to the trial. And according to the state, that is indicative of the fact that they are not really keen about the trial taking place or proceeding at all. The state submitted that the application for contemplated application for direct access had no direct bearing on the matter beforehand. And the state then said the submission by the applicants that the state case is weak and that for that reason they have no incentive to abscond holds no water, because the applicants, otherwise the applicants will not be resisting, the trial on the merits. The state submitted that now the likelihood of the applicants absconding is higher since their legal problems have increased. The state referred to the pending matters. The state submitted that the applicants, being men of means, could sustain life outside the country. The state submitted that upon their indictment, the applicants were served with detailed summaries of the state case together with the copies of the documentary exhibits. They were served with the witness statements. They made a request for further details, and such information was provided to them. Now, the applicants are well informed of the gravity of the case and the gravity, the weight of the evidence against them, and that increases the risk of abscondment. So the state submitted. The state submitted that in the Tapuma case, citation provided, Honorable Mzofa J of this court stated that the court's attention was drawn to the events before the applicant was arrested, and that investigations commenced in December 20th. That was in that case. That he was cooperating with the investigating officer and he had the opportunity to abscond but did not. It was admitted that the state did not point to any instance where the likelihood to abscond can be inferred. The court is alive to the case law on this issue. However, each case depends on its circumstances, which should be taken in totality regarding the factors that should be considered in a bail application. And in that case, the judge still found that there was no basis to interfere with the decision of the magistrate who had denied the appellant in that matter bail. The state said the sentiments by Justice Mzofa apply to this situation, to the present case. My analysis of the facts before me, the submissions before me, is as follows. Bail matters are supposed to be simple, but they end up being complicated because of our uncanny tendency as the legal profession to be unnecessarily creative. Our legal system exists for the sole purpose of resolving disputes with minimum delay. However, as a profession, we tend to become obsessed at times with our own devices and self-interest to the extent of frustrating the wheels of justice. The irony is that in the process of doing that and engaging in gruesome fights over extraneous issues and sideshows, we then end up, say, in a bail application, unwittingly infringing upon the essence of the right concerned. Because we delay matters in the process. We delay the consideration of the entitlement to bail while we are fighting over, issues that we have invented. The legal position is that a bail matter is urgent and should be disposed of with minimum delay. Yet, we were prepared to spend 2 full days sitting up to 6 p.m. to deal with a single bail application. The law on bail is very simple. It has been codified. The statutory framework is in the CP&E Act. Bail rules provide the templates. Even a layman can now file a bail application, because the making of a bail application is informed by templates. The process of determining an application is predetermined. It is guided by sections 117, 116, 117A of the CP&E Act. It is just like completing black spaces in a template, especially after the As I have said, the hearing of this bail application took 2 full days, and that was extraordinary. Ordinarily, a judge is deployed to the bail court, and that judge is expected to hear and rule not less than 20 bail applications in a day, which literally translates to 30 minutes per bail application. But that speedy resolution of bail applications cannot be achieved if we spend 2 days on a single bail application. It is the reason why I say that we really somehow, as a profession, created our side shows. If we had concentrated on what the statute says, we should consider there was no need for 2 days. It will become simpler when I discuss the issue of the argument of what is the nature of the application is before the judge. The simple issue before me was, and remains, whether the applicant should be granted bail after the adjournment of their trial. Mr. Judiciary got it right. I agree with him. They have already been denied bail pending the investigation, and that is a juristic event which is in the past. But what has happened now is that the trial did not take place on the 1st of October 2024. If the trial had taken place on the 1st of October 2024, and if it had been concluded on that day, this bail application would not have arisen. So what has caused this application and necessitated is that the matter was adjourned. And having received that application, the court then must consider that application. It cannot be struck off, because a development has taken place which necessitates not agree or tussled over the nature of the application before me. Counsel for the state argued strenuously that the application before me should have been named a bail application based on changed circumstances. The applicant's failure to give the matter that name was fatal and rendered the application a nullity, and that I was supposed to strike it off. Counsel for the appellants argued equally forcefully and strenuously that what I had before me was an initial bail application, notwithstanding the fact that they had placed on record a previous application and a previous decision by a magistrate to deny them bail. They said I was supposed to treat this application as initial because the application before the magistrate had become extinguished or rendered irrelevant when the applicants were indicted. I should not pay attention to it. It is no longer there. I must hear evidence afresh. I had to disregard all the evidence adduced at the bail hearing. As I said earlier on, I must criticize counsel on both sides. They were just being unnecessarily creative. We do not, as a court, or as a judiciary, or as a profession, legislate. There's no need to give processes or a process that is a bail application a name which does not appear in the CP. When the application, even when a further application is made, it remains just a bail application. I'm fortified in this. If one looks at Rule 90, Sub-Rule 4, it says any application to the judge for bail in terms of Section 116. So that includes the further application of the Act. In fact, all applications start from 116. Shall be filed with the registrar and shall consist of a written statement setting out the information that is there, which includes the name of the applicant, residential address, employment status, and D, well, that is not relevant. The CRB number, the charge, the police record, and whether or not bail has been refused by a magistrate, has been previously refused by a magistrate, and if it has been refused, the grounds on which it was refused, if the grounds are known to the applicant, and the date on which it was refused, and the grounds upon which he seeks release, having regard to the right in the Constitution, and the amount that the applicant offers to pay as bail. Rule 90 is set out in peremptory terms. The word shall is used. What it means that every applicant who makes a bail application must disclose those things, must answer those questions. He must tell the court whether or not bail was refused before by a magistrate. So this argument about what it is, whether it's a further application, what it should be called, is not necessary, because the template in Rule 90 is the same, but it is the information that goes in the template, or the answers to the question in the template, that differ. By the same token, the theory that the bail application in the magistrate court disappeared into thin air and that I must not consider it does not find support in Rule 90. The applicant cannot fail to disclose that. Be that as it may, that forceful submission was made that I must not pay attention to it. But fortunately for the applicants in this matter, they placed that fact before me. They placed the record before me. So, while I disagree with the argument, there was no fatality to the application, because in any event, Rule 90 was complied with. I'm just saying this to show that we delayed this application for no good reason. The applicants realized that the applicants were in custody, and that situation had to be explained. I suggest, however, that it is neater just to name the application an application based on Section 117A of the Criminal Procedure and Evidence Act. Or if it is a further application, then add as read with Section 116, paragraph C, because that quickly draws the attention of the judge to the legal framework applying to the application before him or her. It appears to me that Section 117 helps judges grapple with common law principles of res judicata, issue as to functus official. Because despite the res judicata principle, the issue of the accused is entitled to bail always pops up before sentence. So the an accused person cannot be stopped from applying for bail again and again, as long as there is a basis for it. However, once a judicial officer of competent jurisdiction at any level of the court has pronounced himself or herself based on a set of facts, the courts in general may not pronounce themselves again on the same facts except on appeal or review. In my view, what was of practical significance in this case was just to trace the journey which the applicants have traveled. The journey is signposted by juristic events and judicial pronouncements. One significant juristic event is that bail application was made before a magistrate, and that the application was unsuccessful, and that the magistrate made a pronouncement and found a compelling circumstance. That denial, as submitted by the state, had the consequences that at the time that the appellants were indicted, they were already in custody. Those are the events as they turned out. And that when they appealed against that decision, their appeal was rendered moot by their indictment. in that the warrant of their detention they were being held in terms of a warrant of detention until they appeared before the trial court, and that when they appeared before the court, they will be required to plead instantly, and even if an appeal had succeeded in the air while they were on a warrant, that the outcome would be suspended by their plea, and still the judge would have to decide whether to reinstate the bail or not. And that if the trial failed to start, the applicants would be able to make an application. There's case law to that, because that, of course, is a factor to which triggers a further application. And that the warrant issued would not fall away, even if they succeeded on appeal, because it was already in place. I now deal with section 169. I've already said that the state submitted that it is irrelevant. Section 169 speaks to termination of bail on plea to indictment in the High Court. If the accused is indicted in the High Court after having been admitted to bail, his plea to the indictment shall, unless the court otherwise directs, have the effect of terminating his bail, and he shall thereupon be detained in custody until the conclusion of the trial, in the same manner in every respect as if he had not been admitted to bail. The state takes this to mean that Section 169 is only relevant to people who were on bail, and since the applicants were already in custody, they are not really. But I am of a different view, because the test of what happens to a person who was on bail, whose bail is not resisted, is based on what happens to a person who was in custody after he has pleaded. And that the answer is, so one needs to understand what then happens. So to that extent, Section 169 is relevant to that small extent. But as submitted by the state, correctly, 167 is useful. It then tells us what happens to a person who was not granted bail when he pleads to a charge. In other words, what happened to the applicants when they pleaded the charge while they were in custody. Section 167 answers that. It says that a person, when a trial is postponed or adjourned, the accused person shall remain in custody, or maybe, I've already read that, may be granted bail by the judge, or may have his reconnaissance extended. What it means is that the law has already intervened. If the trial is adjourned, the accused person remains in custody unless he's granted bail. So that is the transition now, from the warrant to the situation that obtains after the accused is pleaded. The state was correct in that regard. In other words, the judge does not have to say anything. Once the accused persons were in custody, Section 169 expects them to remain in custody until the trial is concluded. And when the matter is adjourned, they remain there. But they may be admitted to bail. So the applicants were correct in making this bail application. Because if they didn't, they would remain in custody by virtue of operation of 167. So as I said, the argument was not necessary because the applicants don't seem to realize that they made this application because the matter was postponed, which is a development which necessitated the application. My finding is that it is not correct that the state did not submit any compelling reasons. The approach which the state took is that the bail application which the applicants made in the magistrate court remains an event that has taken place. Evidence was laid, a finding was made, but critically evidence was laid, and they were denied bail, and that evidence is already before me because it has been placed before me by the applicants. It is in compliance with the law. There would therefore be no need to treat this like an initial application where evidence is laid, because the evidence is already there. We cannot close our eyes to what is before us. The issue of compelling circumstances is another, because this court, once an application has been triggered, is allowed to look at that issue again. But of course, taking into account what has already been placed before the court. Because it is conceivable that compelling circumstances may disappear due to developments that have taken place. So, it is not correct that the state did not make any submissions in court. They simply abided by the compelling circumstances that were there and said they persisted. In fact, the state submitted that these compelling reasons have become aggravated by the fact that the applicants have pleaded to the charge. And because of the knowledge of the penalty, if convicted, that they are likely to receive. And the state also submitted that the compelling reasons have strengthened or have become worse because the witnesses' names are now known, the evidence is now known, the reason to interfere and risk is now higher. I notice that the state persisted with two compelling reasons, that is interference and that the applicants may not stand trial. The other, they didn't try to motivate them. They said they are there, but they didn't go on in their motivation support. I would assume that perhaps it's a tacit concession that there may be a change in that regard. However, Section 117 says bail may be denied if one or more of the following compelling reasons exists. So, despite what I perceive to be tacit, concessions or abandonment of compelling reasons, if the state is correct in saying that the likelihood of abscondment persists and the likelihood of interference persists, they would be correct in resisting the granting of bail to the applicants. Now, regarding the seriousness of the offense, I've looked at the presumptive penalty in the sentencing guidelines. The sentencing guidelines is another innovation by the legislature to bring sanity in our courts, where different opinions were expressed. There was inconsistency in the application of the law, just like I commented on the bail rules. Sentencing guidelines now kind of compel us as judicial officers to be guided in sentencing. The presumptive penalty for the fraud case, which the applicants are facing, is 20 years. It says that if a fraud is committed, involves public funds, and there is a huge prejudice, the sentence should be severe. I'm persuaded that the knowledge of that presumptive penalty or the severity of the offense remains and is likely to incentivize the applicants to flee. Something has just disappeared. Just a second. I'll come back to the issue of presumptive penalty later, which I will retake what I've already said about the presumptive penalty because something appears to have been obliterated there. Sorry, I'm left with one page of the judgment, but something has become obliterated. I'll just take about 2 minutes adjournment to get a copy on my desktop of what has been obliterated. I'll take a brief adjournment. apologize for interrupting the reading of the judgment, but that is because I had omitted to pick the last page, the last 2 pages of the judgment, which I left on my desk. So I will start, as I said, from where I speak of the presumptive penalty. I have looked at the presumptive penalty in the sentencing guidelines. It is stated as 20 years. For completeness, I explained that a presumptive penalty is a sentence which the court must start from, depending on whether the crime was committed in aggravating or mitigating circumstances. In other words, if a fraud is committed in aggravating circumstances or any of the listed aggravating factors, the court is required to start from that sentence. It must consider that sentence first. It can go down, it can go up, but for consistency's sake, that is where a court must start. If it goes down, it must justify why it is going down below 20. It's just being guided. There's no question of discretion being taken. If it is going up, in the interest of consistency, it must give reasons for that, so that there's uniformity in sentencing. So these sentencing guidelines now tend to be followed because they in fact say you must follow it, and when you don't, you must give reasons. So that is so in this case it provides for 2 presumptive sentences. Where a fraud is committed in mitigating circumstances, then the presumptive sentence is imprisonment for 6 months. The mitigating circumstances factors are stated as potential and actual prejudice, which is low or insignificant. The other mitigating factor which is stated is that if the offender voluntarily compensated the victim of the crime. Listed as aggravating factors are the following. Item, if a fraud is committed in circumstances where the item or the funds or the property involved are of considerable value, that is an aggravating factor. So the court must start from 20 years and then go down or up, whatever the case might be. If the fraud is committed in circumstances where funds and items involved are not recovered, that is an aggravating factor, which compels the court to start from the presumptive penalty of 20 years and go down or up in its discretion. If the fraud is committed by an offender who is in a position of trust, that is an aggravating feature, and the court must start from 20 years. If the fraud is committed by an offender who is a holder of a public office, that is an aggravating feature. The court must start from 20 years and then justify going up or downwards. If the offense of fraud involves loss of public funds, that is an aggravating feature. The court must start from 20 years and either go down or up in its discretion and justify the course it has taken. I observe that if the state proves its case, the accused persons would be guilty of an offense which involves a huge amount of public funds. It would be an offense where it's rather a considerable value, public funds, and funds that were not recovered. I know that the accused persons are innocent. Bail application is just based on likelihoods. And the state has submitted that realization that they are at risk of a heavy penalty. It could be an incentive. Is an incentive rather for them to abscond. I will consider that submission. Basically, on the face of it, it is a reasonable submission. But I must consider that in light of the authority, rather the surety that has been tendered, and balance that. Section 117, subsection 2, regarding which says accused person may be denied bail if he is not likely to stand trial, also gives us the factors. And the factors are those: the offense, the gravity of the offense, the sentence that is likely to attend, and the concomitant incentive to flee, the ties of the applicant to the court. The applicants in this matter reside in Harare, they are family men, they are businessmen, and I have to balance that. But having balanced that, I am persuaded by the state submission that the risk of abscondment has increased, notwithstanding the security that the applicants have followed. We take into account the reality that even people that offer security do abscond at times. So that's why I say it's about likelihoods. That is accepting that they have ties to this court, and that the accused persons are denying any involvement in this matter. Yes, the accused persons submit that the trial may not be concluded soon, because there are other issues at stake. What normally is of consideration, which normally constitutes changed circumstances and which affect compelling reasons, is the delay which was occasioned in commencing the trial. This trial is already in progress. It has commenced, so it has not been delayed. It's in progress. And as I've said, it has just involved many issues. But nobody can complain that the trial has been delayed. So to that extent, the delay in concluding the trial is not really a factor that has changed anything. The trial started almost promptly. It was just delayed by 1 day. And this matter has really been given priority in the third term. It really got priority. It displaced all other trials that had been set before me during the third term. Well, except one, which also involved accused persons who were in custody. The matter is receiving priority. It had to be set for continuation next month, not less than 30 days from now. If approached correctly, this trial may conclude in less than 5 days. So we hope to conclude this trial in February, which is next month. The applicants initially referred to the application for direct access, but during argument, they considered that that is a separate process, which does not affect the trial, at least for now. I accept, but in terms of whether or not the defense will succeed, I do not wish to delve into that, because we just have pleadings here. We have the state case, we have the defense case. Those are matters for the trial. But I would expect that the applicants are eager to have their names cleared, since they are businessmen who don't need serious allegations hovering above their heads. So, all matters being equal, this trial should conclude in February, when we tackle it in earnest. I do accept the submission by the state that the situation is turned for the worse with respect to the applicants, in the sense that they have another matter which is ready, which also involves public funds and which is ready for trial, and according to the state, which may be put to trial this term. If we go by presumptive penalties, again, they are at risk of a huge penalty. That the matter is ready, that is going to be tried this month, has not been disputed, and the state says they are in custody on that other matter, and if they are admitted to bail, they may flee. I'm just saying this because previously there was no consensus regarding the weight to be attached to pending cases, because some judicial officers thought that a pending case remains a pending case, where which is affected by the presumption of innocence, unless the accused person has got a previous conviction. But it appears the legislature intervened to resolve the lack of consensus and said the applicant is compelled to disclose pending cases and whether or not he has been admitted to bail on that pending case. He was also naturally expected to disclose previous conviction, but that doesn't relate to the accused persons. They are innocent in every respect, but that the disclosure has to be made. It has to be made in a bail application, and because the legislature expected it to be a relevant consideration. One will look at section 117, subsection 2, the factors relevant to whether or not they are, it says any other factors, and the infusion of this means that the court is given to the court because the court should take it into account. I'm therefore persuaded that it is relevant. It is a relevant consideration with regards to propensity and with regards to the incentive to flee. I therefore find that two of the compelling reasons found by the magistrate, which are the likelihood that the applicants may not stand trial or that the applicants may interfere, still persist, and in the result, the application for bail may not succeed, and I therefore dismiss it.
Please.
Any other business register?
No further business.
The court will rise.